Esquire Counsel, State Counsel 2, appearing for the defendants, submitted a single issue for determination, to wit, whether the claimant has sufficiently established a case against the defendant and is thus entitled to relief sought. In arguing the sole issue for determination, counsel submitted that the claimants failed to sufficiently establish a case and is not entitled to grant of the relief sought. It is also submitted that the grant or refusal of declaratory reliefs as being claimed by the defendant is discretionary to be exercised judicially and judiciously. A plaintiff seeking the grant of declaration must succeed on the strength of his own case and not on the weakness of the defendant's case. In support of this submission, counsel relied on Wire versus Aka. He also stated in Amobi versus Ogidi Union Nigeria Limited and others, the court has stated the burden of proof to be on the claimant in establishing her entitlement to the declaration. Counsel praised reliance on the foregoing case and submitted that the claimant hearing has failed to prove her case in accordance with the law. Counsel also submitted that the case of the claimant, the claim of the claimant that she participated and was successful in the recruitment done by the third defendant has not been proved by the claimant. As there was no evidence adduced by the claimant in proof of such assertion. Counsel submitted that the evidence the claimant adduced is oral evidence attempting to establish contents of document which the law does not allow. Counsel submitted that based on the foregoing, the only possible way to establish content of a letter of the alleged would be the production of the original, which the claimant has failed to do. Counsel also relied on the case of Ogunu versus Amcon on this issue of not tendering the original letter of purported employment. Counsel submitted in this case the claimant failed to produce the letter, which is the primary evidence that is required to establish a case. The counsel submitted that claimant having failed to tender the relevant evidence has failed woefully to establish a case, and counsel asked the court to dismiss the claimant's claim as lacking in merit. And for failing to meet the requirement of the evidential proof. Finally, on the issue, counsel submitted that on the mandatory injunction sought, it is submitted that it is only when the declarations succeed that an injunction can be granted. Claimant having failed to prove her declaration is not entitled to grant of an injunction. On the last release by the claimant grant of award of damages, it is submission of counsel that once principal orders sought in an action are refused, the order incidental to the principal can also not be granted. In support of this, counsel relied on the case of Awoni versus registered trustees of Amok. He also relied on the case Ukerele versus First Bank of Nigeria. Counsel submitted that the above asked the court to hold that the claimant has failed to prove her declaratory reliefs and also the other reliefs which depend on the grant of declaration. In concluding his submission, counsel asked the court to discountenance the case of the claimant, refuse to grant the prayer sought, and dismiss the suit for lacking in merit. The submissions of the claimant on the 24th day of May 2023, the defendant closed their case and the parties were ordered to file their final written addresses. The matter was adjourned to 20th day of July 2023 for adoption of final written address. On the 10th of July 2023, the claimant filed what she called her final written address that was not signed by her counsel. On the 24th day of July, when this matter came up for adoption of final written addresses, the claimant informed the court that she has debriefed her counsel and needs time to engage another counsel. Consequently, the claimant was given more time to engage new counsel to prosecute her case. However, on the 28th day of February 2020, on the 28th day of November 2023, when this matter came up for adoption of final written addresses, the claimant informed the court that she could not get counsel within Cross River State and she has to go outside the state to procure a lawyer and could not afford the cost. In the circumstances, the claimant informed the court that she would like to adopt her address. The court, after appraising the situation, deemed the final written addresses of the parties and that of the claimant as having been argued. However, a perusal of the claimant's written address will clearly show that the address of the claimant was not professionally done, and there are a lot of mistakes and confusions in it. In the circumstances, the court decided not to reproduce the said address in the judgment. A careful perusal of the will show that it is full of contradictions and contain irrelevant authorities. This clearly shows that there is no professional touch in the said final written address. In the circumstances, I shall discountenance the address more particularly when it was by unqualified person to make such a submissions of law before the court. After all, an address is not compulsory, it is only to assist the court in arriving at a just decision. Court decision, I have considered the processes filed, the evidence laid by the parties, and the final written address filed by the parties in supporting their respective positions before the court. The claimant in this case is seeking for declarations that the unlawful swapping of the claimant letter of employment details for another is illegal and should be held. The claimant is also claiming an order for mandating first dependent to issue her letter of appointment. Furthermore, and the final relief is for the sum of 60 million naira as general damages or compensation for hardship the claimant is made to undergo till determination of this suit. It is clear to me the declaration being sought by the claimant in relief 1 is the main relief in this suit, while reliefs 2 and 3 are ancillary reliefs which depend on the grants of the main reliefs, that is the declaration. From the pleadings and evidence adduced before the court, the claimant grounds against the defendant is that the first defendant placed an advertisement for online recruitment of teachers to be handled and or conducted by the third defendant. The claimant applied for the said applied for appointment as a teacher. She was eventually shortlisted for the interview. Exhibit A was tendered in evidence as proof of shortlisting of the claimant for the interview. According to the claimant, she attended the interview and passed, but her appointment letter was not delivered to her, even when she cited it in the office of the third defendant with computer number 500005571. Consequently, she complained of the fraudulent action of the third defendant, but it fell on deaf ears. She also wrote petition to the Assistant Inspector General of Police Zone 6 in Calabar for investigation. While waiting for the outcome of investigation, she instructed the law firm of CO Ukaibo and Associate lawyers, her solicitor, to write to the third defendant demanding for an appointment letter. In August 2022, the third defendant was conducting a redeployment promotion interview for current primary school teachers in Akpabio, Yakur, and Abi local government area of the state, and the claimant applied for same thinking that it was a fresh recruitment. However, on getting there, she again cited her letter of appointment. Despite several letters written, the defendant have refused to release the claimant's letter of appointment or give reason why the letter would not be released to her. The law is right that a claim is circumscribed by the relief sought. The duty of the plaintiff or claimant, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. He may, at the end of the day, obtain all the relief sought or some part. He may, at the end of the day, obtain all the reliefs claimed or less. He never get more, nor does he obtain what was not claimed before the court. A court is therefore bound to grant only reliefs claimed. It cannot grant reliefs not claimed. See Gabriel Atibi versus Kabel Metal Nigeria Limited. What this decision postulates is that for the claimant to succeed in getting the court to grant her reliefs or to grant her claim, she must adduce credible evidence in proof of her case. This is in line with the requirements of the Evidence Act by Section 131, 132, and 133 of the Evidence Act. It is settled that he who desires any court to give judgment on his legal right and liability dependent on existence of facts which he asserted has to prove those facts exist. The burden of proof in a suit proceeding lies on the person who would fail if no evidence at all were given on either side. In this case, it was the claimant that desired this court to grant reliefs, claimed on the basis that the facts she asserted in her pleadings existed, and it was her case that would fail if she failed to adduce evidence to prove the existence of those facts. The claimant could only secure a favorable judgment she desired on the strength of her case established by legal burden of proof upon which the success of the case depends. See the case of APC versus Obaseki. In the case at hand, It is the duty of claimant in this case to prove every abatement in her pleadings, particularly where issues are duly joined or on such pleadings, where no satisfactory evidence is laid in proof of any part in issues, the court would be entitled to dismiss such issue. In relief one, the claimant is seeking for a declaration that the unlawful swapping of her letter of employment details and also seeking for she for the claimant seeking the declaration, she has the burden to prove her entitlement by cogent, compelling, credible evidence. It is when the claimant has discharged this burden that the burden will now shift on the dependent to disprove. See Aguasim versus Jiwere, see also Oga versus Ikpeabo. The claimant in this case has the burden to prove relief sought in the statement of claim. For the claimant to succeed in her relief declaration, the onus on her to satisfy the court on the evidence adduced, she is entitled to the declarations being sought. To put it differently, in every civil case, the primary duty lies on the claimant to prove his case, and unless he does this, the court, he cannot succeed. Considering the position of the law on the burden of proof, can it be said in the circumstances of this case, taking into consideration evidence adduced before the court, can it be said that the claimant has proved her case or discharged the onus of proof imposed on her by the law and is entitled to the relief sought? The claimant testified as CW1 in proof of her case and tendered documents which were admitted in evidence and marked as exhibit. Accordingly, the claimant in her testimony testified that she is employee of the first dependent engaged by the third dependent, but has not produced any letter of employment in proof of her assertion. The dependents on their part have denied being employers of the claimant. Having denied the assertion of the claimant, the burden is on the claimant to prove that the dependent employed her. This can only be done by credible evidence adduced in proof of the employment. Having failed to produce evidence on her appointment with the defendant, the claimant with the evidence before the court, she is not employee of the defendant, as she has not proved to the court that she was ever employed, as there was no such evidence before the court. Apart from her oral testimony, swapping of her employment details, the claimant, apart from the list of shortlisted candidates that attended interview, has not produced any document showing her scores at the interview for the court to verify her claims of passing the said interview, and had not called any member of the panel that interviewed her to give evidence of her scores. This means that the claimant of passing interview is based on the claimant's wishful thinking and not based on concrete evidence. Claimant G accused one Ms. Emila as perpetuating some criminal activities since 2018 on the recruitment exercise. She also claimed Ms. Emilia was in the possession of her letter of appointment. She further stated that she was invited to documentation and collection of appointment letter at West Africa Institute, where she was told by one official that her name is not on the list, but hopefully it may be in the next batch since she was invited verbally. It is surprising that the claimant did not make the Miss Emilia as one of the defendants in this suit, since the defendants have denied that the claimant was employed and the claimant has insisted that her letter of employment is with the said Miss Emilia, and Miss Emilia, in collaboration with staff of SUBEV, the third dependent, deprived her of her appointment. The claimant has a duty to ensure that Miss Emilia and her collaborators who denied her appointment letter or swap her details are made parties in this suit. Because by the claim of the claimant, they are proper and necessary parties to be sued in this case. Having not sued Miss Emilia and her collaborators, who are by the claim of the claimant necessary parties in this suit, the claim has woefully failed to prove any swapping of her appointment or even existence of the purported appointment. The claimant's evidence on issue of swapping of her details has no legal or factual basis. The insistence of the claimant that she demanded for her letter of appointment, which she was not invited to collect, cannot stand, as there is no evidence before the court in proof of that abatement. From the evidence before me, the claimant insistence to pursue this suit was misplaced priority, having regard to the categorical denial of employment of the claimant as per Exhibit DW1A, which the claimant refused to collect, and Exhibit K, which was a reply to Exhibit J by her counsel. This exhibit have clearly pointed to the fact that there was no any employment relationship between the claimant and the defendant, based on which rights and obligation inures. This means on declaration has not been proved. This also means the remaining two reliefs, which are ancillary to the main reliefs for declaration, they are as well dismissed. From what I have been saying above, the claimant in this case has woefully failed to establish any employment relationship between her and the defendant by any written document, which this court could look at to determine the rights and obligations of the parties in this suit. The claimant has not also been able to establish any contractual relationship by conduct of the parties. There was nothing before the court to show that by conduct, the defendants have taken the claimant to be their employee. And there was nothing before the court which shows that the defendant has performed any duty or any function to the defendant which will warrant the court to come to the conclusion that she is actually an employee of the defendant and entitled to be issued with letter of appointment. From the claimant has woefully failed to prove her case as required by the law. The claimant case lack merit, same is hereby dismissed. I make no order as to cost party to bear their respective costs. Judgment accordingly.
To do.
Call the next case.
Yes, my lord. Suit number NIPN-CA 42-2023 between Professor Cyril Osim Ndifon and 1, the Vice Chancellor, University of Calabar. 2, the registrar. Push that woman out. Lock that door. Lock the outside. I'm very sorry, my lord. It's the claimant on the other matter that is disturbing us.
Why is the court orderly? Let her, let him take her out.
That's my lord.
Yes.
My lord, okay, suit number NICN CA42-2023 between Professor Cyril Osim Ndifon and 1, the Vice Chancellor, University of Calabar, 2, the Registrar, University of Calabar, 3, University of Calabar, 4, Professor Dorothy Oluwagbemi Jacobs, for herself and on behalf of members of panel investigating conduct leveled against Professor Cyril Ndifon. My lord, the parties are absent.
Appearance.
Announce.
May it please, my lord. May my lord be.
I can see the claim. I say I can see the claimant counsel. He is to announce appearance first.
May I please, my lord, Chief Oguji, my lord, my humble appearance for the claimant. Yeah, keep it directly to me. Yes, my lord.
Chief Oguji, you are not properly dressed.
My lord, I just got the information now, my lord.
No, you have the information. You know this matter is coming up today. You were in court when this was adjourned to today.
Yeah, my lord. We said you were not around, my lord. We thought the matter was not coming up again until I was just told some few minutes. Now, my lord, I'm sorry.
Yes. Any other appearance?
May my lord be pleased. Donald Achibom appears for all the defendants on record, sir.
Yes, this matter is for judgment. The judgment of the court is ready. And it will be read shortly. Yes, this is the judgment of the court. But considering the time constraint, I will not read out the entire judgment. I will only read the decision of the court. All the preliminaries will be skipped. Counsel, when they get the hard copy, they can have opportunity of reading the introductory aspect of the case. The introduction includes the reproduction of the questions for determination. I have also reproduced the reliefs being sought by the claimants. I have also captured the case of the claimant as gathered from the affidavit, evidence, and further affidavit and the exhibits. I have also captured the case of the defendants as can be gathered from their counter affidavit and the exhibit attached therein. I have also captured the argument of the issues submitted in the written address of the claimants, the 3 issues. I have as well capture the argument of the defendants on the three issues formulated in their written address file along with the counter affidavit. I have also reproduced the argument of counsel, what he termed rejoinder on points of law. So counsel will have, when they get the hard copy, they will have opportunity of reading all these submissions. However, I will go straight to the
Decision
of the court now. This is the decision of the court. I have considered the originating summons commencing this suit filed by the claimant, the affidavit in support, the counter affidavit of the defendants, and the further and better affidavit in support of the originating summons. I have also considered the written and oral submissions of counsel for the parties in arguing their cases. In the originating summons, the claimant formulated 3 questions for determinations, which I have already reproduced in the body of the judgment. So no need of reproducing them here again. In the originating summons, the claimant formulated 3 issues for determination, and in anticipation of favorable determination of the said questions in favor of the claimant sought for 10 reliefs from the court, which I have also reproduced in the earlier part of this judgment. In the written address filed by the counsel for the parties in support of their various positions on the claim of the claimant, they submitted 3 issues for determinations each. These issues clearly are not worded as in the same way the questions submitted in the originated summons were awarded. They were slightly different. It is to be noted that a careful perusal of the entire content of the provisions of Order 3 of the rules of this court, which the claimant used in filing the originating summons, it will be clear that originating summons is one of the processes recognized for commencement of an action before this court. For any person that is interested, under an enactment, constitution, agreement, or any other written instrument, may by originating summons apply to the court for determination or construction of his entitlement. This is what the claimant has done in this case. A party activating the originating summons to ventilate his grievances is duty bound to comply with the rules of the court. The rules of court clearly envisage that the originating summons must contain questions or questions for construction arising under the instrument involved and declarations of persons' interest. The declaration of right depends on the answers to the question formulated for determination for the and effect-saving procedure. This effect-saving procedure of Order 3 of the National Industrial Code must raise the questions or questions for determinations on which the claimant seeks court determination. This means the real issue placed before the court are the questions raised in the originating summons and not questions raised in the written address in support of the originating summons. The choice of counsel to formulate different questions that different from the questions submitted in the originating summons was wrong. This court will restrict its consideration of the origination summons based on the 3 questions formulated and submitted in the originating summons commencing this action. Where an issue is not properly raised before the court, it has no business whatsoever to be dealt with. However, a court must confine its step to the issues raised by the claimant in the originating summons. In the instant case, it was the questions that accompanied. It is the questions and the accompanying reliefs or praise that the claimant raised relied In the circumstances, the court also must rely on the questions and the relief sought by the claimant, and none of the parties, either the court or the parties before the court, are allowed to deviate from the case set up by the claimant, more particularly where there is no counterclaim, as in this case. The 3 questions formulated by the counsel for the claimant as contained in the originating summons are been reproduced in the earlier part of this judgment. They need not be reproduced again. The facts based on which the claimant brought this action against the defendant are straightforward. The claimant has stated that he is a professor of law and elected dean of the faculty of law of the third defendant, because before issuance of Exhibit 9, at the instance of first defendant, the claimant was by the Exhibit 7 queried on several allegations leveled against him. The claimant replied the query, stating his defenses to the allegation leveled against him. The reply in Exhibit 8 attached to the affidavit in support of the originating summons. Upon receipt of Exhibit 8, the first defendant directed the second defendant to issue Exhibit 9 to the claimant, relieving him of his position as Dean Faculty of Law and placing the claimant on suspension from duties with effect from 17th of August 2023. In the letter of suspension, the claimant was asked to stay away from the premises of the third defendant while the bossa of the third defendant was asked to place claimant on half salary throughout the period of suspension. By Exhibit 10, the first defendant set up a panel headed by the fourth defendant to investigate the allegations leveled against the claimant, which include sexual harassment and abuse of office. The claimant, being aggrieved by the content of Exhibit 9 and 10, instituted this action by way of originating summons seeking for resolutions of 3 questions in his favor and grant of 5 declarations and 5 other reliefs. I note that question 1 and 2 are interwoven. In the circumstances, I shall take the 2 together in determining them. The 2 questions have raised propriety of removal of claimant from the position of Dean of Faculty of Law, to which he was elected without prior vote of the faculty board as provided in paragraph 8 of section 6 of the 3rd schedule to the University of Calabar Act. The second question is on alleged violation of claimant's fundamental rights to freedom of movement as enshrined in section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Article 12 of the Africa Charter on Human and People's Rights. The encompassing argument in favor of issue 1, counsel for the claimant made reference to Exhibit 3, evidencing election of claimant as Dean of the Faculty of Law, University of Calabar, for a second term of 2 years. Council also refers to paragraph 8.1 of the third schedule to the University of Calabar Act and argued that his tenure as Dean, Faculty of Law is a statutory tenure to which the claimant is entitled to serve and hold his office for the duration of 2 years. It is the submission of counsel that due process of law for removal of Dean of Faculty of Law has not been as prescribed, has not been followed. It is submission of counsel that due process of law for removal of Dean of Faculty clearly prescribed under combined provisions of Section 16.3 of the University of Calabar Act and paragraph 8, 6, and 7 of the third schedule to the Act. Council submitted the power to remove Dean. The power to remove Dean is vested in the faculty and not in the first dependent. After vote had been taken at the meeting of the board for a Dean to be removed, there must be good cause, and faculty must vote. Faculty board must vote for such removal. It is submitted in the absence of the board voting. The removal of claimant by the first dependent is a clear usurpation of the exercise available power, as there is no provisions of the law or regulation of the third defendant authorizing the first defendant to remove claimant. The removal is ultra biased, null and void according to the counsel for the claimant. Counsel heavily relied on the case of University of Nigeria Teaching Hospital Management Board versus Inoli, Tufra, and that of Patrick Majid versus University of Agriculture, Makodi, and argued that where a public body fails to comply with certain procedural safeguards in an enabling act or regulation, there is breach of duty imposed on it. Counsel referred to these two cases and argued that where a public body fails to comply with certain procedural safeguard in an enabling act or regulations, there is breach of duty imposed on it, and its decision in such circumstances is ultra biased. On the second question, counsel submitted the Constitution is supreme law and shall have binding force on all authorities and persons throughout Nigeria, and any policy, act, or law by any person or authority which is consistent with any constitutional provision shall be void. Council relied on Section 1, subsection 3 of the Constitution in making this submission. According to Council, the directive for the claimant to stay away from the third defendant premises except one responding to invitation from panel of investigation. An order imposed on the claimant is curtailment of the right to entry or movement into, within, or out of the university premises. This infringes his freedom of movement guaranteed under Section 41 of the Constitution. For the defendants, apart from the power of council of the university to suspend, terminate claimant's appointment provided under Section 16.3 of the University of Calabar Act, and power of the faculty
$1 So where are you spelling?
For the defendant, apart from the power of the council under Section 16, subsection 3, and paragraph 8, subparagraph 6 of the shared schedule to the University Act, there is provisions in Section 16.2 of the University of Calabar Act, empowering the first defendant to suspend the claimant from performance of his duties. Counsel submitted the claimant is a staff of the third defendant, which is not in dispute, is under the authority of the first defendant as well as the counsel of the third defendant. Counsel also argues that the mere fact that the claimant has been elected for a fixed term of 2 years does not mean Counsel insisted that the first defendant has the requisite power to suspend the claimant under Section 16, subsection 2 of the University of Calabar Act. On claim of violation of claimant's fundamental right to freedom of movement, counsel for the defendant refers to the case of Iowa versus University of Jos Sufra, where the Supreme Court stated that the law is that a master can suspend his servant when necessary, and there can be no issue of breach of fundamental rights. Counsel also argues that reliance on the claimants on the case of Okapo versus Lagos State government is out of context, and that case is distinguishable from the case at hand because that case deals with the restriction of movement during environmental sanitation. On Article 18 of the Africans Council also argued that Article 18 of the African Charter there has been no evidence adduced on violation of Article 18 of the African Charter on Humans as Human Rights. Therefore, the first defendant or the defendants have not in any way infringed claimant's right to family life. Resolutions of the two questions. The defendant's quarrel in this case is on Exhibit 9 and 10, issued on the instruction of the first defendant, suspending a removal of claimants from deanship of the Faculty of Law. He is also quarreling with the portion of Exhibit 9, empowering restriction on the claimant's quarrel is with the suspension, or is with Exhibit 9 and 10, which suspended him from office and removed him from being Dean Faculty of Law. Let me say that employment cases, whether the employment is one governed by statute or not, the employer has unfettered right to suspend the employee to pave way for investigation into allegations of misconduct leveled against the employee, which may lead to disciplinary action. Which may lead to taking disciplinary action against the employee. This power is exercisable to enable conduct of investigation. See the case of Nitel versus PLC versus Aqua. See also Omojo Moju versus Groups Security of Nigeria Limited and others, where there is allegation of misconduct, an employer has the right to suspend employee pending the outcome of the investigation into the allegations. On this point, reliance was placed on the case of Komolong Miafen versus University of Jos Consultancy Limited, where considering the extant law governing the claimant's employment whether considering the extant law governing the claimant's employment, the dependent can be said to willfully fail to comply with the laid laid down rules and procedures in suspending the claimant, thereby rendering the said suspension wrongful, unconstitutional, null and void. The term suspension in the employment context refer to state when any employee is temporarily debarred from his employer for the time being from performing any of his official functions or enjoying certain privileges. In other words, it means an order suspension of employee is issued to keep away the employee from the exercise of his official functions or enjoyment of the certain privileges. Suspension is not capable of putting an end to the contract of service relationship without more. The relationship is only put on hold temporarily. The Supreme Court has the opportunity of defining the term suspension in the case of Longe versus First Bank of Nigeria PLC, where the court has this to say: the word suspension means a temporary prohibition or deprivation, cessation of stoppage, or from
Sanusi, Kado.
the word worried or conveyed a temporary or transient disciplinary procedure which keeps away the victims or person disciplined from his regular occupation or calling either for a fixed or terminal period or indefinitely. The disciplinary procedure gives the intention of the give the initiation of discipline a period to make up his mind as to what should be done to the person facing the discipline, although it must, in most cases, suspension result in a disciplinary action. It is not invariably so. There are instances when the authority decides not to continue with the matter. This could be because the investigation did not result in any disciplinary conduct. See Fa Oguntade JSC. End of quote. For a decade, JSC, as his name was, suspension is usually a prelude to dismissal from an employment. It is a state of affairs which exists while there is a contract imposed between the employer and the employee. But while there is neither work being done in pursuance of nor remuneration being paid, suspension is neither a termination of contract of employment nor is dismissal of employee. It operates to suspend the contract rather than terminate the contractual obligation of the parties to each other. The case of the claimant is that Exhibit 9, letter of his suspension and removal from office is wrongful, non-compliant with due process and procedure, and therefore unconstitutional, null and void, and of no effect whatsoever. The claimant has stated that he was elected as Dean Faculty of Law for a second term of 2 years by the first, for a second year, for a period of 2 years, and he has, and that the first dependent has no bias to issue Exhibit 9. I have examined the provisions of Section 16 of the University of Calabar Act, which make provisions for disciplinary discipline of staff, including the claimant, as well as provisions of paragraph 8 of the third schedule to the University of Calabar Act, which makes provisions for election of dean of the faculties and their removal. As argued by counsel for the defendant, a schedule to an act cannot operate to override the main provisions of the act to the schedule on. As for any schedule to have legal efficacy, must conform with the main statute. In the case at hand, Section 16, subsection 2 of the University of Calabar has conferred on the first dependent power to suspend any erring staff from performing of his duties. There is no dispute that there are allegations of misconduct leveled against the claimant, and it is based on these allegations that the first dependent it is based on those allegations that the first dependent exercised her power conferred on her by Section 16, subsection 2, to suspend the claimant from performing his function with effect from 17th day of August 2023, pending the investigation into the allegation level against the claimant. I find and hold that the first dependent has requisite power under the law to suspend claimant from work or office or performance of his duties when such is necessary. From the case of Longe versus First Bank, it is clear to me that in suspending employee, restriction can be imposed on the employee This restriction cannot by any stretch of imagination amount to violation of fundamental rights of the suspended employee. In the case at hand, the directive to the claimant to stay away from work except on invitation of the panel of investigation is in order. It is meant to ensure speedy completion of the investigation and prevent interference by the claimant of the evidence and witnesses for the conduct of the investigation. The restriction is in order and does not violate any of the provisions or any of the provisions of the articles on African Charter and People's and Women's and People's Rights. There is also nothing before the court to establish violation of claimant's rights to family life. I think the restriction imposed on the claimant relate to his office and performance of his official functions as an academic staff of the third defendant. The said restriction does not extend to his residence or his family. The claimant is only making fanciful argument on the issue of restriction of his movement. The claimant has not informed the court that the claimant has in any way curtailed or restricted him from accessing his residence or having access to his family. The defendant by Exhibit 9 has not violated the right of the claimant or breached any of the claimant's fundamental rights. The claim of the claimant that his freedom of movement has been violated has not been proved, as the defendant in the case at hand has the requisite power to suspend the claimant and impose a restriction concerning the said suspension. The claimant has also argued that the first defendant does not have power to remove him from deanship of the Faculty of Law, as it is only the board of the faculty that has such power to remove him. And for such to happen, the board must, a meeting must be convened, a meeting of the board must be convened for that purpose, and a vote has to be taken for claimant to be removed. Going by the clear provisions of paragraph 8, subparagraph 6 of the third schedule to the University of Calabar Act, and considering the provisions of section 16.2 of the University of Calabar Act, conferring power on the first defendant to suspend claimant from work, can it be said that the position of the schedule to the University of Calabar Act will operate to derogate the efficacy of section 16.2 of the University of Calabar Act? The simple answer is capital no. The provisions of the schedule will be redundant once the first defendant has exercised her power under the Constitution. This is because, going by the Supreme Court decision in Longe versus First Bank, once the employee is suspended, he can no longer perform the function of his office until after investigation and decision of the employer whether to recall the employee or press with the charges of misconduct against him. See also University of Calabar versus Esiaga. Taking into consideration the positions of the law on suspension and the content of Exhibit 9, one will be correct to state that the correct interpretation to be given to the words one will be correct to state that the correct interpretation to be given to the words relief of your position as dean as contained in Exhibit 9 is that the claimant is being asked to stop acting as dean of the Faculty of Law because he is on suspension and the matter is to be investigated. Even if the wording of the letter will mean claimant has been removed from office of the dean, that will not in itself be used to nullify Exhibit 9 and 10 as for the simple reason that being that with the suspension of the claimant, he cannot perform the function of the office as he is no longer to perform most of functions. Taking into consideration the position of the law on suspension and the content of Exhibit 9, one will be correct to state that the correct interpretation is that the relief of your position as dean simply means that the claimant is being stopped from performing of the function of the office of the dean of the Faculty of Law, which even without a letter of indicating such, the suspension of the claimant by the first defendant based on the allegation level against him means that the defendant cannot continue to perform the function of the dean, the office of the dean, as he is no longer allowed by law to perform such functions with his suspension. In the circumstances, the claim of the claimant that Exhibit 9 and 10 should be nullified because there was no requisite power for the first claimant to remove the claimant from the deanship cannot stand, as even with service as the foundation based on which his election was made into the office of the Dean Faculty of Law was him being an employee of the service perform such function. I saw fine and hold. I found that the test defendant has the requisite power to suspend the claimant and the suspension stand. The use of the word relief of duty cannot make any difference. I now go to the last question, which is question number 3. The claimant is of the view that his contract has statutory labor in the circumstance of disciplinary matter is not left at the discretion, whims, and caprices of the employer. Rather, the procedure for discipline is clearly defined and must be followed, failing which any disciplinary action will be declared null and void. According to counsel, the setting up of first defendant headed by post defendant did not comply with Regulation 5661, which has spelled out setting up the Management Disciplinary Committee, which is to be headed by DBC administration, and the fourth defendant is not DBC administration. First defendant has no power, therefore first defendant has no power to set up the said panel headed by fourth defendant. The panel, as the said panel, is unknown to law. In their reaction, the defendant submitted that the claimant is acting under false assumption, that the function of the investigative panel set up by the first defendant is the same with the function of management disciplinary committee created by Regulation 566 of the Conditions of Service. It is clear from the wording of Exhibit 10 and even paragraph 22 of the written address of the claimant that the panel set up by the first defendant is an ad hoc panel for investigative purposes. It was never set up as a disciplinary panel to try claimant for any misconduct. The job of the panel is a fact-finding committee to verify the allegations leveled against the claimant and make appropriate recommendations for taking further action for taking further necessary action, either to proceed with the disciplinary proceeding against the claimant or to terminate such proceedings. The panel, being a committee set up for fact finding, is not an illegal or unlawful or null and void. It is properly set up within the powers of the first defendant as chief executive officer of the third defendant, saddled with the responsibility of day-to-day running of the affairs of the third defendant. Even in Bamboye versus University of Ilorin, the status of the disciplinary committee set up by the rules of the setups by the conditions of service was considered by the Supreme Court, and the Supreme Court came to the conclusion that even such committee cannot be delegated the power of discipline. So the committee set up by the first defendant is not a committee for discipline, and the first defendant cannot even set up a disciplinary committee. It is only the council of the university that has the power to set up a disciplinary committee. But the first defendant has the requisite power to establish a committee for a fact finding to enable the first defendant to come to a decision as to whether there is a prima facie case that need to be proceeded against the claimant or not. With regard to paragraph 23 of the affidavit in support, there seems to be misconception regarding the panel set up by the first defendant to investigate the allegations against the claimant, and a disciplinary panel or committee meant to discipline the claimant for any infractions of regulations or policies of the third defendant. The first defendant, as the administrative head of the third defendant, is close with the requisite power to investigate issues of infractions or violations of regulations in her own way. The method adopted by the first defendant for fact finding cannot be questioned, as that the panel is not acting as a disciplinary committee to discipline the claimant. It is not in any way set up to determine any rights and obligation concerning the employment of the claimant. The claimant clearly misconceived the setting up of the ad hoc committee for the investigation of the allegations leveled against the claimant. From all I have been saying above, the claimant has woefully failed to convince the court that he is entitled to any of the declarations or orders sought before the court. The case of the claimant is premature, as there was no disciplinary action commenced against him or conducted based on which he can approach the court for determination of its propriety. The claimant's case is therefore frivolous, devoid of any merit, and same is hereby dismissed. However, before I end this judgment, let me say that this case has raised issue of timely putting up governing councils of universities in Nigeria. This case is a clear proof that the absence of governing councils in universities in Nigeria, federal universities in Nigeria, is throwing the universities into confusion due to the fact that by law, certain functions have to be performed or done by the council, and the absence of council is a hindrance to such smooth running of the university, as there are limitations as to what can be done in the absence of the council. In the circumstances, there is urgency for setting up of councils for all the universities in Nigeria so as to ensure smooth running of the universities. There is also the need for the legislature to amend the acts establishing the universities in Nigeria to make provisions for allowing certain functions that are meant for the council to be performed by the administrators of the universities in the absence of the councils. This will go a long way in ensuring the smooth running of the universities. From all I have been saying above, and from my findings, the claimant has failed woefully to establish his case. All the questions have been resolved against the claimant, and the case of the claimant is hereby dismissed for lacking in merit. I make no order as to cost. Judgment is entered accordingly.
As the court pleases.
Yes, Registrar.
My lord.
Any other matter?
No, my lord, that's all for today.
Okay. Thank you very much, counsel, for being with us.
Thank you, my lord.
Okay, I wish you all the best. We have come to the end of the virtual sitting. The administrator, you can end the sitting, please.
Thank you. Will appeal. No, the matter is that the law should state that the provision of God give the vice chancellor powers to suspend And the committee so panel said, but not a discipline panel, but a fact-finding panel to establish the propriety otherwise of allegation of misconduct that the matter was brought prematurely